Okay guys, so in this video I am going to read, this video is going to be the Obergefell v. Hodges opinions. I am going to start by reading the holding, opinion, the dissent from Justice Roberts, the dissent from Scalia, the dissent from Thomas joined by Scalia, and the dissent from Alito joined by Thomas and Scalia. So, let's get started. Held, the 14th Amendment requires a state's license a marriage between two people of the same sex and to recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. The petitioners seek marriage because of their respect and need for its privileges, responsibilities, as illustrated by the petitioner's own experiences. The history of marriage has been one of both continuity and change. Changed understandings of marriage are characteristic of a nation where new dimensions of freedom become apparent to new generations. Cultural and political developments allowed same-sex couples to lead more open and public lives. The fundamental liberties protected by the 14th Amendment's Due Process Clause extend to personal choice essential to individual dignity and autonomy, including intimate choices defining personal identity and beliefs. Courts must exercise reasoned judgment in identifying interests of the person so fundamental that the state must accord them its respect. When new insight reveals discord between the Constitution's central protections and a received legal structure, the claim to liberty must be addressed. The court has long held the right to marry is protected by the Constitution. Loving invalidated bans on interracial unions. Turner held that prisoners couldn't be denied the right to marry. In assessing whether the force and rationale of its cases apply to same-sex couples, the court must respect the basic reasons why the right to marry has been long protected. The first premise of this court's relevant precedents is that the right to personal choice regarding marriage is inherent in individual autonomy. The connection between marriage and autonomy is why Loving invalidated interracial marriage bans. This is true for all persons regardless of sexual orientation. The right to marry is fundamental because it supports a two-person union unlike any other in its importance to committed individuals. Marriage safeguards children and families and thus draws meaning from related rights to childbearing, procreation, and education. Without recognition, stability, and predictability marriage offers, children suffer from the stigma of knowing their families are somehow lesser. Court cases and traditions make clear that marriage is a keystone of social order. There is no difference between same and opposite-sex couples with respect to this principle, yet same-sex couples are denied benefits that states have linked to marriage and are co-signed to an instability many couples would find intolerable. It's demeaning to lock same-sex couples out of the central institution of society, for they too aspire to the purposes of marriage. The decision is also derived from the 14th Amendment's Equal Protection Clause, recognizing that new insights and understandings can reveal unjustified inequality within institutions once passed unnoticed and unchallenged. The court has invoked equal protections to invalidate same-sex marriage bans and confirmed the relation between liberty and equality. The marriage laws at issue here are in essence unequal against a long history of disapproval. This denial works a continuing harm to disrespect and subordinate gays and lesbians. While the Constitution says that democracy is the process for change, those who are harmed need not await legislative action before asserting a fundamental right. Hey, sorry, I know that was really fast. I was interrupted during 2 takes of this, so kind of, yeah, I've repeated this several times. And I just ripped the page, dang. So that was the holding of the court. Next we have the opinion of the court, delivered by Justice Kennedy, joined by Ginsburg, Breyer, Sotomayor, and Kagan. So, here we go. The Constitution promises liberty to all within its reach, a liberty to define and express their identity. The dynamic of marriage allows two people to find a life that cannot be found alone. Choices about marriage, quote, fulfills yearnings for security, safe haven, and connection that express our common humanity. Civil marriage is an esteemed institution, and the decision whether and whom to marry is among life's momentous acts of self-definition. Through the enduring bond of marriage, two persons together can find other freedoms. This applies to all persons regardless of sexual orientation. There is dignity in the bond of two men or two women who seek to marry in their autonomy to make such profound choices. If rights were defined by who exercised them in the past, received practices could serve as their continued justification, and new groups cannot invoke rights once denied. This court has rejected that approach both with respect to the right to marry and rights of gays and lesbians. Rights rise from a better understanding of how constitutional imperatives define liberty that remains urgent in our own era. Many who deem same-sex marriage wrong reach that conclusion based on religious or philosophical premises, and neither they nor their beliefs are disparaged. When personal opposition becomes law and policy, the consequence is to put the imprimatur of the state on an exclusion that demeans or stigmatizes those whose liberty is denied. Same-sex couples seek in marriage for that same legal treatment as opposite-sex couples, and it would disparage their personhood to deny them this right. Baker v. Nelson is now overruled. An individual can invoke a right to constitutional protection when they are harmed, even if the broader public disagrees and legislators refuse to act. The argument that same-sex marriage will harm the institution by causing a decrease in straight marriage rests on a view that straight couples' decision-making regarding marriage and personhood. Those decisions are based on many personal considerations. It is unrealistic to conclude that straight couples will choose not to marry simply because gay couples may do so. The respondents failed to prove that same-sex marriage will cause harmful outcomes. These cases involve only the rights of two consenting adults whose marriages will pose no harm. Religious people do not have to perform same-sex marriages. The state cannot bar same-sex couples from marriage. Okay, that's the holding. Next, we have the dissent from Justice Roberts. So, the dissent from Justice Roberts is not short. So, yeah, buckle up, guys. The court is not a legislature. The morality of same-sex marriage is of no concern to the courts. The courts are only authorized to give judgment. The right to marry does not include the right to make a state change its definition of marriage. The people of a state are free to expand meaning of marriage to include same-sex couples or maintain the historic definition. Stealing this issue from the people will cast a cloud over same-sex marriage, making dramatic social change more difficult to accept. The majority decision is an act of will, not judgment. The right has no basis in the Constitution or precedents. This judgment is about whether the decision should rest within the people or five powerful lawyers. Marriage arose in the nature of things to meet a vital need, ensuring that children are conceived by a mother and father committed to raising them in stable conditions and of a lifelong relationship. The human race must procreate to survive. Procreation occurs through sexual relations between a man and a woman. When a child is conceived, the child's parents are generally better if the mother and father stay together. By bestowing a respected status and marital benefits on married couples, society encourages men and women to have sex within marriage. To those who drafted and ratified the Constitution, the conception of marriage and family was a given. Its structure, stability, roles, and values accepted by all. The Constitution says nothing about marriage, and the framers entrusted the states with the whole subject of domestic relations of husband and wife. Everyone assumed marriage was between a man and a woman since the founding. Multiple dictionaries define marriage as a union between a man and a woman for over a century. The court's precedents have repeatedly described marriage in ways that are consistent only with its traditional meaning. The majority's approach has no basis in principle or tradition except for the unprincipled decision of judicial policymaking that characterized and discredited decisions. The majority argues that laws violate an implied right by the 14th Amendment's requirement that liberty may not be deprived without due process of the law. Our precedents have required that implied fundamental rights be objectively deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if they were sacrificed. The marriage laws at issue involve no government intrusion, they create no crime and impose no punishment. Same-sex couples remain free to live together, to engage in intimate conduct, and raise their families as they see fit. Justices must exercise judgment and restraint. Privacy cases provide no support for the majority's position because the petitioners do not seek privacy, they seek public recognition of their relationship as well as benefits. The only precedent that offers any support for the majority's methodology is Lochner v. New York. The freewheeling notion of individual autonomy echoes nothing so much as, quote, the general right of an individual to be free in his person and in his power to contract in relation to his own labor. That's my dog. I am not going to pause this because this is my third take. So, the majority doesn't support that its individual autonomy is entirely unconstrained. The constraints it sets are precisely those that accord with its own reasoned judgment, informed by its new insight into the nature of injustice, which was invisible to all who came before, but has become clear as we learn the meaning of liberty. Today's decision rests on nothing more than the majority's own conviction that same-sex couples should be allowed to marry because they want to, and that it would disparage their choices and diminish their personhood to deny them this right. This belief has no more basis in the Constitution than did the naked policy preferences adopted in Lochner. The majority randomly uses the word "to" in various places, but offers no reason why the two-person element of the core definition of marriage may not be preserved, but not the man-woman element. It is striking how much the majority's reasoning would apply with equal force to a claim of a fundamental right to plural marriage. Why would there be any less dignity in the bond between three people who seek the choice to marry? And then he goes on to talk about polygamous marriages. So, next, a justice's commission does not confer any special moral, philosophical, or social insight sufficient to justify imposing those perceptions on fellow citizens under the pretense of, quote, due process. And then he talks about how the only process that is due is the democratic process. So, the court overlooks our country's entire history and tradition, as well as actively repudiates its preferring to live only in the heady days of here and now. To blind yourself to history is both prideful and unwise. The laws at issue here do not violate equal protection because distinguishing between opposite and same-sex couples is irrationally related to the state's, quote, legitimate state interest in preserving the traditional institution of marriage. The respect of the court flows from the perception that we exercise humility and restraint in deciding cases according to the Constitution and law. The court today is anything but. The majority's conception of judicial supremacy is evident in its description and dismissal of public debates. Our founders would not recognize the majority's conception of judicial rule. They risked everything for the right to govern themselves. It is demeaning to the democratic process to presume that voters are not capable of deciding an issue of this sensitivity on decent and rational grounds. The court's accumulation of power comes at the expense of the people. When decisions are reached through democratic means, some will be disappointed, but they know that they had a say. The court put a stop to that. Closing debate tends to close minds. Some are less likely to accept the ruling of the courts. The proponents of same-sex marriage lost the opportunity to win true acceptance that comes from persuading their fellow citizens of the justice of their cause. Federal courts do not have the flexibility of legislatures to address concerns of parties not before the court or to anticipate problems that may arise from the exercise of a new right. Today's decision creates serious questions about religious liberty. The majority assaults the beliefs of fair-minded people who follow the traditional definition of marriage. The legitimacy of their power depends on confining it to the exercise of legal judgment. People have the right to celebrate the decision, but not the right to celebrate the Constitution, because the Constitution had nothing to do with the decision. I respectfully dissent. So, and that was the dissenting opinion by Justice John Roberts. Some of my pages ripped, so that's annoying. Next, we have the dissent from Justice Scalia. That is it's only like 2 pages long, so it's not like John Roberts. So, I agree with the opinion of Roberts. I write separately to call attention to the threat to democracy. The substance of today's decree is not of immense importance to me, and then he goes on to say that the law can recognize whatever it wants. It is important who it is that rules me. Today's decree says the ruler of 320 million Americans, coast to coast, is a majority of 9 lawyers on the SCOTUS. The majority in these decisions is the furthest extension of the court's claimed power to create, quote, liberties that the Constitution fails to mention. This robs the people of the most important liberty in the Declaration of Independence, the freedom to govern themselves. Public debate over same-sex marriage displayed American democracy at its best. People on both sides passionately but respectfully tried to persuade fellow citizens to accept their views. Americans considered the arguments and put the issue to a vote. The Constitution places some constraints on self-rule. Then he mentions the full faith and credit clause and the Bill of Rights. Aside from these limitations, powers, quote, reserved to the states or people can be exercised as the states and people desire. These cases ask us to decide if the 14th Amendment contains a limitation requiring states to recognize and license same-sex marriage. Is that issue removed from the political process? No. The authors of today's opinion 2 years ago said the regulation of domestic relations in an area that has long been regarded as a virtually exclusive province of the states. The federal government has deferred to state law policy decisions with respect to domestic relations. When the 14th Amendment was ratified, every state limited marriage to 1 man and 1 woman without doubt of constitutionality. And then he says that we should stick to what the people believed when the 14th Amendment was ratified. So public debate over gay marriage must continue. States are free to adopt whatever laws, even those that offend the esteemed justices' reasoned judgment. A system that makes people subordinate to 9 unelected lawyers does not deserve to be called a democracy. Judges are selected for their skill as lawyers. Their views on policy are and should not be relevant. And then he talks about how undiverse the background of the justices are and how the Supreme Court does not fully represent the U.S. The justices in the majority are comfortable concluding that all states violated the Constitution between the 14th Amendment's ratification and Massachusetts allowing gay marriage. The majority's opinion style is pretentious and its content is egotistic. The opinion stands for nothing except the freedoms and entitlements this court really likes, and the Equal Protection Clause identifies only a difference in treatment that this court really dislikes. With each decision that takes a question away from the people that is not based on law, but on the reasoned judgment of a bare majority of this court, we move one step closer to being reminded of our impotence. Okay, that was Scalia's dissent. Okay, so all the background noise you hear is either my dog barking or construction, because this is a new neighborhood and like half of it is still under construction. So, okay, this is the dissent by Justice Thomas, joined by Scalia. That is only, let's see, it's only like 2.5 pages long. So, the decision today is at odds with the Constitution and principles upon which our nation was built. Liberty has been understood as freedom from government actions, not entitlement to government benefits. The Constitution was made to preserve that understanding of liberty. The majority invites judges to rule based on their personal views instead of the Constitution. In order to invoke due process, a party must identify a deprivation of life, liberty, or property. The majority claims these state laws deprive petitioners of liberty, but the idea of liberty it conjures up bears no resemblance to any plausible meaning of the word as it is used in the Due Process Clause. And then Thomas talks about Magna Carta, which is due process, and he says that liberty is freedom from physical restraint. And the Fifth Amendment uses the word liberty in a narrow sense, so we should assume that the 14th Amendment is narrow as well. So, whether we define liberty as locomotion or, okay, that was an old definition of liberty, or freedom from government action more broadly, petitioners have in no way been deprived of it. The petitioners seek benefits that exist because of government. Receiving governmental recognition and benefits has nothing to do with any understanding of liberty that the framers would have recognized. The right to marriage would not have included a right to government recognition and benefits. It would include the right to engage in the same activities that petitioners have been free to engage in without government interference. And then he talks about previous cases where where individuals were not solely denied government recognition and benefits associated with marriage. He talks about how, like, for example, in Loving, the petitioners were arrested. So, the majority's evasion of the original meaning of liberty will likely cause collateral damage to other aspects of our constitutional order that protect liberty. The majority disregards the political process as a protection for liberty, and then he talks about the importance of democracy. What matters is that the process established by those who created the society has been honored. The process has been honored here. The definition of marriage has been subject to heated debate, and state legislature have taken up the matter, and states have put the question to a vote. In 32 out of 35 of those states, people have opted to retain the traditional definition of marriage. The fact that petitioners disagree with the result of the process doesn't make it any less legitimate. Their civil liberty has been vindicated. The majority decision threatens the religious liberty our nation has long sought to protect. People have come to the U.S. to seek religious liberty. The commitment to protect religious liberty has been reaffirmed over and over. Marriage is not only a governmental institution, but also a religious institution. It appears all but inevitable that the two will come into conflict as individuals and churches are confronted with demands to participate in and endorse civil marriages between same-sex couples. Although our Constitution provides some protection against government restrictions on religious practices, people have elected broader protections than this court's precedents mandate. The majority will go to great lengths to assert that the decision will, quote, advance dignity of gay couples. The flaw is that the Constitution contains no dignity clause. If it did, the government would be incapable of bestowing it. Dignity has been understood to be innate when the framers proclaimed that all men are created equal and are endowed by their Creator with certain unalienable rights. They referred to a vision of mankind in which all humans are created in the image of God and therefore of inherent worth. The corollary The principle is that dignity cannot be taken away by government. Slaves did not lose their dignity. Those held in internment camps did not lose their dignity. Those denied government benefits did not lose their dignity. The government cannot bestow or take away dignity. Then he talks about how the laws in question have nothing to do with dignity, and the majority is misguided on the definition of liberty and due process. So, next we have our last opinion, that is the dissent from Alito, joined by Scalia and Thomas. This is only about a page long. So, the Constitution leaves the question of gay marriage to be decided of the people of each state. The Constitution says nothing about a right to gay marriage, but the court holds that the term liberty in the Due Process Clause of the 14th Amendment encompasses this right. The court has held that liberty under the Due Process Clause should be understood to protect only those rights, quote, deeply rooted in the nation's history and tradition. The right to gay marriage is not among these rights. The majority claims the authority to confer constitutional protection upon that right simply because they believe that it's fundamental. Then he talks about various current views of marriage, like it's for happiness, stuff like that. Today, 40% of children are born to single women because of changes in our society's understanding of marriage. States that don't want to recognize gay marriage have not given up on the traditional understanding. They worry that abandoning the older understanding will contribute to marriage's further decay. Then he talks about how the reasoning in this case can be exploited, and the majority marginalizes those who oppose gay marriage. And then he says that everyone should worry about Supreme Court overreach. So, those are the opinions of the Obergefell case. The next video is going to be Engel versus Vitale, which is one of the required cases for AP Gov.